Everybody's back. Call entry. I think I got Andrew. Who you? Oh, okay. She in the restroom, Judge. Miss D. Williams in the restroom. Not yet. She should be coming through in a second. She's in the restroom. And she's back.
That's where my brain works. Slow down. Mario. Slow down.
I can do that.
People working.
I was going too fast.
You do speed tests? How fast can you go?
Alright, I'll keep that up. This is a quick transcript to be prepared.
Yeah, okay. I didn't want to get covered. Big road, right? Yeah.
On the record. Sorry, I know everybody here?
Yes, sir.
Okay, thank you, sir. First order of business, Mr. Uhelski, if it's your task of preparing the suitable order on behalf of the state, is it?
It is.
Okay. 12 April. That's when you have to file a suitable order and send it to your colleagues for my consideration on the motions in limine, motion to strike, in regards to Mr. Stillwell and his motion to exclude irrelevant and prejudicial audio and video, and Mr. Williams' amended motion, limiting motion to strike number 2. All right, sir? Okay. All right. As a matter of housekeeping, councils as well, I am in possession of Mr. Williams' motion to enforce disqualification that was made orally last week by Mr. Steele, filed on yesterday evening. Ms. Love, if you could file, you and your team or the state file a response no later than by 5 o'clock on the 3rd of April, and I will take up that motion at 9:30 on April the 4th.
Yes, Your Honor.
I will hear argument on that motion, and that motion alone that morning, and that would be the conclusion of our business.
Yes, Your Honor.
And also, Ms. Love, whoever files a response on your behalf, I need to get receive a copy of that. And counsel, this is one of the things I was going to talk with y'all about. The court is not ordinarily an e-file party, meaning I don't get if you file a motion, I'm probably going to regret doing this. But if you file a motion, if you don't make me an e-file, click, the court, like you have Mr. Kearns, I won't get a copy of it. You can do that, or my preferred ask is that you just send me a copy of whatever it is. Okay, so if we have to argue a motion and I've told you to take it up, please just make sure that Mr. Kearns gets a copy, I get a copy. You can do that by forwarding it to me directly to my county email, or just attaching that as an attachment, just making sure that you've copied the rest of the parties, and I can get it that way, because that's part of the challenge. I don't get a lot of your pleadings and other things that I just need to be made aware of, just so I can kind of track them. All right. Okay. All right. Okay, I've had an opportunity to read and consider the motions filed by Mr. Kendrick. That is the motion to limit witnesses due to undue delay, waste of time, and or needless presentation of cumulative evidence, filed on the 19th of March of this year. Also, amended motion to limit the witnesses due to undue delay, waste of time, and or needless presentation of cumulative evidence, and that was filed on the 22nd of March. And then I've also had an opportunity to take a look at the state's response to defendant Demontre Kendrick's motion to limit witnesses, filed on the 1st of April of this year. Councilors, I've had an opportunity to read your motions, and I really don't need any oral argument on it. I'm going to go ahead and give you my thoughts, okay? And then we can talk any further if necessary. Let me start out first by a brief procedural history of where we are and where the court thinks we are, which you can correct as need be. This case was indicted or we had and/or arraignments May of 2022. The court then started having proceedings over the summer of 2022. We started motions on or about the 20th of December of 2022. We summoned jurors for January of 2023. We selected a jury on or about 15 November of 2023 and started the presentation of evidence soon thereafter. And up to this point in time of April the 2nd, I should say, of 2024, we have summoned some 40-something witnesses at this point in terms of just a rough framework of what has gone on in this particular case. Now, in reading your issues, Mr. Weinstein, as well as Ms. Love, in terms of the delay, I'm going to group them in two separate, because I don't want you all pointing fingers at one another, and there's enough blame to go around to everybody, all right? But there seems to be two issues and two categories that issues kind of get presented. And the first one is, even though the state has released tranches of discovery over the course of the past year, some of it is untimely, and it causes, this is information evidence that the defense claims that they haven't seen or has been augmented or has been, they just didn't get. And a big example was last week when we had the testimony of Ms. Bennett, and even though there were interviews and or text messages that were available, they were not disclosed until the witness was on the stand. Now, the court understands the ebb and flow of trial and understands that sometimes things happen. And in taking a look at the appellate case law that we've talked about earlier in regards to exclusion, and this is not the first time the court's been asked to exclude evidence by the defense or made such arguments. Mr. Steele has made these arguments before. Mr. Weinstein has made these arguments before. And several of you have made these arguments before in terms of just of non-disclosure and that they should be excluded. But that's just one example of where the state could have and should have provided those particular statements earlier and text messages. And what this does is, when we have a jury seated in the box where Sergeant Ingram is right now, and I say, is there anything else that we need to take up? I'm really just kind of being polite. I really am. I really don't expect you all to have anything other than maybe something that's ministerial in nature. We seem to be taking up more and more substantive issues when I ask that question. And it's my pattern and practice to ask that because I don't want there to be anything that's a surprise that we certainly shouldn't have taken up earlier. So it causes great delay. And that is something that the court has indicated to all counsel that is a challenge and a problem, and doesn't make your case in the best light it could. So that's why I would rather not call or have jurors present if you all have substantive things to take up that I'm made aware of. And you probably heard me say before, a forewarned judge, a happy judge. So, I mean, it's true, because then I can kind of take up things and I can kind of tell the jury, consistent with your ability to try this case without delay and interruption, and put you all in the best light possible in front of this jury. So that's one set of examples of is the disclosure or non-disclosure, or the alleged non-disclosure, okay? So And I've had to excuse our jurors sometimes for hours in respect to try and unravel issues that you all presented before the court, which you needed to, but we could have taken this stuff up much earlier and resolved that without our jury being present or our jury being in the box. Okay? The second category of issues that both sides argue, or then the court has seen presented in this case, is the defense claims that the state didn't disclose or give evidence which was not disclosed in discovery. So, and some of this may or may not have been disclosed in discovery or not. And I find that I have to kind of then unravel that particular issue. Sometimes we sit here in front of a jury and not in front of a jury, but while the jury is in their headquarters, and we have to unwind that. And there are a number of times that both of you, but the defense, I'm going to pick on you, Mr. Weinstein, you filed a valid set of motions and an amended motion, but this morning I got 15 amendments to it. Now, the people from the Catholic school did teach me how to read, but I can't read that fast. Okay, so, but you filed some 15 addendums and everything else that you wanted me to look at.
Can I briefly respond?
No. Let me finish. The challenge is that if you package them and give them to me earlier, then I'll be, like I said, I'll be a much happier person. The more you can give me, the more ahead of time, I'm very much appreciative. I'll read anything you want me to read, but the sooner you can get it to me, the better off I'll be. But the point being is that I cannot take up your issues while we have jurors waiting to come out. And that seems to be the biggest argument that we have between both of you. And I've told you that this is something that certainly bothers the court, because we have been here this amount of time. Now, related, Ms. Love, I asked you have you gotten the list of potential witnesses and the days you think you're gonna take to present the rest of your case in chief? Just ballpark.
Your Honor, I don't have that for the court, but
Okay, all right. I told you to have it today, okay? And this is one of those things that I tell you all. I mean, it's just like what I tell you all is not aspirational. There's a reason I ask you for it. And this is exactly what I'm complaining about at this point. You told me you were going to have it, because I told you we were going to have, first we're going to have these motions on Monday and Tuesday, but unfortunately I had a funeral I had to go to yesterday. But so you've had at least a week or so for you to pull this together and for you to kind of, because I wanted to know how many more witnesses and how many more days. And I told you ballpark, and the evidence that you and Miss Hilton and your team is kind of putting together, but that's not ready, is it?
Your Honor, what we have been factoring in was the data that we will not be in court. So we have got.
I just asked.
The brief answer is that is not ready at this
time. How many days more of trial do you think that your case in chief will take?
I could
30, 40, 50, 60? Tell me how many more days you think you're going to have. I asked you to come up with that number because that's.
I believe that, I'll give the number of days.
All right, just sit there and think about it. I'm going to come back to you in just a second, okay? But this is a challenge because it's been brought to the court's, allegation that I'd like to, while you all need to try this case, and it needs to be fairly tried as to both sides, we have jurors that, we need to present this case in a more expeditious and streamlined fashion. And this is just part of when I ask you to do something, please do it timely. And this is a problem. But we're going to come back to this, all right? So that's part of the challenge in this case. We started out with some 700 witnesses. We came down to 400. State says, well, we got about 200 and thereabouts. And that's kind of what I was going to inquire about today. So I'm going to come back to that in just a second. But I've also, to let you all kind of handle your business, I provided you several administrative days, which I've invited and directed counsel to iron out any preliminary issues that that the court may have to take up beforehand, and file suitable motions so that you all can have this before me, and then I can kind of, okay, we got to take up 2 or 3, we've heard these phone calls. There are some issues that kind of came out with that. It's going to take a day. Then I don't bring this jurors back yet for another day, or we plan on it, and then we can take up that. So that has been a challenge, and it's caused a lot of start and stops with our case. So, in looking at 24-4-403, Mr. Weinstein, I don't believe that it does comport to your, even though you and Mr. Apt have artfully kind of fashioned that motion, 403 has to be specifically applied to a particularized situation. It's not that I don't take it, and it has to be taken up on an individual basis. I understand globally what you're asking me to do, and I understand the frustration, but I'm not gonna apply that to it quite yet. However, I am gonna apply 24-6-611, because that gives me broad authority to exercise reasonable control of the presentation of witnesses and evidence to avoid needless consumption of time and other things. So to that event, what I am going to do is I'm going to initiate the following, and I'm going to put it in an administrative order. And here's what I'm going to do. On Mondays, Thursdays, and Fridays, we're going to start at 8:45 and reclaim a little bit of time. So if you need to take up anything, we'll go ahead and take it up before a jury gets here. That's number one. There's 5 things I'm going to implement. 2 is going to be the exclusion of any evidence, documents, or pictures that aren't timely disclosed. So, defense, if you argue that that they haven't been timely disclosed, it will be the state will have to tell me what date and did you disclose that particular evidence or discovery in the same or substantial format that it was given to the defense. So, because what I'm having is I'm getting, the state changes it or expands it or just comes into possession of it. So if it hadn't been disclosed already, you tell me, for example, we gave that to the defense on April the 15th of 2023. And you can show me that it has been in fact filed that day, then we'll proceed. If not, I have remedies. The remedy, I'll exclude it, or I'm going to excuse the jurors on the spot, and they're gonna come back the next day, and we're gonna work to resolve that. But I'm not gonna have them sitting here every day, and then they're gonna, of course, make certain judgments for themselves. I'm not gonna say anything, but I told you that the biggest thing that jurors complain about is having us to sit back there. Also, if it's so number 2 is I'm going to start excluding stuff that if it's changed from discovery, hasn't been disclosed in discovery, or I'm going to reserve the right to go ahead and exercise that remedy at that point in time. So defense, if you're going to make that argument, you need to be able to tell me what's changed about the particular evidence. If so, because after the state tells me, okay, well, we gave it to you on the 23rd, well, then you have to be able to tell me, here's what else they gave me. So I may just exclude that portion of it. So I'm going to start just excluding stuff in that respect because it's not timely. But whoever the proponent of the evidence or asked for the exclusion is going to have to tell me, well, when did you disclose it, and in what form did you disclose it? So, because this is why I've told you all, get together earlier, talk to one another, and if you have problems, then certainly or issues I need to resolve, file a motion, let me know so I can go ahead and take it up. But I'm hearing about it a lot of times the first time when the jury sits in the box. And I can't do that. It's not fair to them, not fair to me as your trial judge to be able to rule on those kind of things. So related, number 3 is I'm going to start, if appropriate, and I do need to take up something that is of that important or import, I will go ahead and excuse our jurors, and just we'll take whatever, and we'll come back the next day. So that's 3. Number 4 is I have spoken with our sheriff, and consistent with court, if necessary need be, we'll start having court on Saturday and Sunday. Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up, I think we need to work a little harder in terms of being able to streamline, and that goes to both sides. And look, I don't want to work that way too, because it's me and my staff and my team and the sheriff and his team and everything else. But we will do it because we're going to have to recap some days. I don't want to be in 2027 trying this case. Or as Mr. Steele said, I want to be here next Super Bowl trying this case. I'd like to have it. I'd like to go watch the Super Bowl without having to come back to try your case. I hope that your case is resolved by that time, whatever may happen. But I think that we can do a better job at presenting the evidence and streamlining whatever for the fact finder to be able to make a decision. So we're going to start gathering on Saturday and Sunday. And the last remedy, and I don't say this being otherwise mean and contrary and everything else, but I have power of contempt. I don't want to use that. I don't. But it's come down. We've been in trial a long time. I think I've been very clear with everybody about my expectations, which serve you all and your ability as advocates in this case to try the best case you have. So that's why I said I wasn't going to kind of let you all start pointing fingers at each other, because I think there's enough blame to go around. But you all are going to have to, as I've said before, do better. You all are very seasoned advocates. So I shouldn't be having these many discussions and interruptions. I mean, and I'm in no way saying you're not doing your jobs, because that's what you're paid to do. You are doing your jobs. But the challenge to the court is that we've had a lot of interruptions with the jury sitting in a box. And I've told you my concerns about that. So that's where I'm going to draw a line. And I've thought long and hard after these motions. I was thinking about this prior to Mr. Weinstein filing his motions and the supplemental motions to limit the witnesses. But I have to do something that will at least make us or force us to go ahead and make sure that we can present a case to the jury that is more streamlined and not stops and starts. I mean, if we get 2 or 3 hours a day, we're doing good, because we had so much interruption. And a lot of that interruption was needless. It could have been taken up much earlier. So, so that's where I am at this point in time. Now, back to my original ask, Ms. Love. How many more days do you think that you'll have?
Your Honor,
How many more days and witnesses do you think you'll have?
we think about 150 witnesses, Your Honor, and roughly 100 and roughly 120 days.
That's 4 months?
Yes.
Have you all, now is this 120 days of actual like
We were trying.
5 days a week or what?
Right. We were trying to. This is what we were trying to achieve. This is what we're trying to achieve. That's what we were trying to achieve. Yes. So we were trying to, with the tearing down and with the previous information I had shared with counsel for the defendants, this is what we were trying to achieve with our prior requests and information that we relayed to the court. But that's not inclusive of the length of time it would take counsel to cross-examine all of our witnesses. We just don't have that. We can't factor that in. We don't have any way of estimating that or factoring that part in.
Are these may call or will call witnesses?
The
Witnesses you
remaining witnesses are the definitely will call. There may be more. These are the ones that we have pared it down to, Judge. We made our best effort. We don't know if something will arise that will require that we pull in another witness that we provided the defense notice of, depending on how the witnesses change their testimony based on whatever questions are asked during their examinations. There may be occasions where that number changes, but that's the number that we had provided to counsel for the defendants previously, prior to this motion being filed, and that is the number that we expect to be able to present our case with.
Okay. Oh, you sit down, ma'am, please.
Oh, thank you.
All right, let me ask the state a question. I know that we've touched this before, but does this purported 150 witnesses comport with the rest of the accounts or overt acts that you attempted to prove in your case in chief?
Yes, this is I think I understand the court's question. This is the number of witnesses. This is the most pared down. This is what we expect that we hope to be able to prove everything that we intend to put before this jury in our case in chief with these witnesses. If something goes differently than we anticipate, if some objection is made, if that is sustained, that requires that we call in an additional witness here or there to prove particular points, then we would supplement that list to that extent, but we don't expect that would increase our numbers by any great percentage.
Okay.
So this is for the entirety of the rest of what we anticipate presenting to the jury in our case in chief. So it includes the counsel on the indictment. It includes overt acts, intrinsic evidence that we intend to introduce. We have served upon counsels for the defendants all of the acts, intrinsic, overt, that we intend to introduce evidence of. And so there's nothing within those witnesses that is not contained in the information that we have provided in terms of what we intend to prove. But this is as pared down as we've gotten it.
Okay, so these are the list of 150 are your the witnesses you will call.
Yes.
Okay. All right. Here's what I want you to do. Pursuant to OCGA 1716.3, I want you to update your witness list.
Mm-hmm.
You have the ability to call anybody that, to supplement supplement, depending upon what other evidence is adduced or is presented that may require you to impeach or rebut or to the like, to account for variances in presentation of evidence. So I'll allow you to amend to supplement your witness list, but for good cause.
150.
But I want to see the 150. I want to see them in terms of the law enforcement and what they're going to testify to, and lay witnesses and what they're going to testify pursuant to counts, overt acts and/or counts. And any expert witnesses that you were going to call.
Okay. So that I understand, the court isn't asking that we give the strategy to. The court is just saying, generally speaking, this act, this, that,
Yes.
this, the other.
At this
Okay.
point, there's not any. One of your predecessors told me once, said, "I'll give you my entire file because if you can beat me with it, you deserve to win." And I think at this point in time, the caliber of lawyers that you have in this courtroom, there should be no surprises. And I'm of the opinion that more disclosure just fosters
I understand what
openness in the proceedings and with what's being presented. So at this point, it's not like anybody's going to be surprised with anything you come up with. At least you shouldn't. There shouldn't be. But I think that in order for us to keep this thing going smoothly, or as smooth as possible, the less interruptions that the court has, the better off we'll be in terms of terms of evidence and presentation in front of this jury. So I want that by tomorrow morning, because what I'm going to do is I'm going to take a look at my calendar, and we're going to kind of block it. I'm going to see whether or not we are going to meet 4 months or not.
That does not include the length of time.
Well, you can come on the weekend, Mr. Matthews. So don't worry. So don't worry about that. Okay. You let me take care of that. But okay. But
That does not.
that's part of the calculus.
I was going to say that does not include the length of time that. has
Sure,
been
I
taken.
know that. I know that. But what it does is it kind of puts us on a path that at least I'll know and your colleagues will know, hey, where we are in terms of, so I can start to plug and play and see if we're behind. Because we're behind, I'm going to make you come during the weekends.
Okay.
I mean, I'm just going to start doing that because we need to kind of press a little bit harder, or else, as Mr. Weinstein have said, we'll be here in 2027. And that's not what I want for this jury. We need to put this case to them in a fashion that is fair and reasonable. But I think that at this point in time, Ms. Love and all defense counsels, I think if you iron out and we don't have these hiccups where you all are like, where the state says, well, we gave you 3 things in discovery and now we have 5. And the defense says, well, I need to take up these other 2, which we haven't been given, or we got them this morning, or we got them a couple of days ago, and I haven't had their option to do that. And you want to go ahead and present them. So that's why I'm saying if you all talk with one another, I mean, you might be able to, I know that you want to present the cases linear as you can in front of the jury, but sometimes that may not be we might not be able to do that because of what comes up. So I'm going to help focus you all a little bit better.
Your Honor, with respect to the second point that the court will be implementing in order to facilitate the presentation of the information to the jury.
That's the exclusion?
Yes, of any documents not timely disclosed. So when we stand up, Your Honor, to present or to show something to the witness, it will not include anything that has not been served. But what we are doing is showing to counsel for the defense the numbered exhibits.
Here's what I don't want to hear. Here's what I don't want to hear. Ms. Hilton, a couple days ago, we just found this last night on the person's Instagram.
Your Honor, so.
Okay, that's what, and then.
It was just it had just recently been posted.
Well, then you should have grabbed that, and whatever time that it was given to you, if it was 6 o'clock in the morning, should have been forwarded over to them so they can kind of say, look, this just got posted, whatever else. Then that's kind of, everybody knows. Everybody knows you're probably going to introduce that evidence, and then they can talk with their client, whoever else that posted it, and they can kind of say, well, they can have meaningful discussions, but it shouldn't be done right while our witness is on the stand. That's just another example.
Yes, Your Honor.
Okay, I mean, that's what I'm saying to you. I mean, in terms of, if you get something, it needs to be disclosed immediately, and then you need to kind of let the court know first thing in the morning or as early as you can, saying, we're going to have to take this issue up. What I'm finding a lot of times is the witness is on the stand or the jury's in a box, and we're having to take up that. And we're doing that more often than we are the exclusion rather than the rule. So that's what I mean.
Your Honor, and will the court also just mandate that we provide to each side our numbered exhibits prior to even approaching the witness with them, so that we have them? Because
it would be helpful, because if you already disclose those in discovery, but what I'm finding is happening is your colleagues say, nope, we haven't gotten that. But you should be able to tell me, Judge, we gave it to him on June the 15th, and it was in this particular disclosure, and this is where it was. Yes, because that's part of their challenge. I mean, they're like, we got 8 terabytes worth of stuff.
We have been providing to them the exhibits we intend to introduce. We're just asking that that be required of both sides, so that, for instance, before Mr. Kokomo or someone else approaches the witness with
I will make that as part of the defense if they wish to go ahead, and as long as it falls within the rules of the rules that remember,
that we have.
They're not in their case in chief yet,
No,
and they don't have to do anything. So part of the rules don't necessarily apply to them the way they apply to the state at this time. And I know that's frustrating, but that's just part of it. But to the extent that any defendant's going to use any evidence that I'm going to need to rule upon, I do need as much notice as I possibly can at this
Your Honor,
point.
what I'm specifically speaking of are physical exhibits that are numbered. There may be on a PowerPoint 25 pictures, and we can't even pose or make an objection or say we don't have any if we don't know what exhibits we're looking at. So we're just asking the court require that we be given a physical copy.
But a lot of times this is evidence that you've already given them.
It is. And so if they're giving it to the witness, we don't know if it's defense 1, 2, 3, so that we can know what it is we're objecting to or not objecting to, so that it's not just on a computer. If we have a physical copy of it like we provide to them, labeled already, then we can make a more expeditious announcement to the court.
To the extent that the defense has any materials, it would be helpful for you to show those to the state prior to your presentation, so we don't have delay. To the extent that you can. So I'll make that part of my order, but it's really going to depend upon.
And I don't mean far in advance. I mean prior to saying we're approaching with some pictures, so that we can at least know what it is that we're talking about, like defense 1 through 12. If we could just have them, a copy of them, that would be great.
Well, I'll say this: as long as if it involves anything that wasn't disclosed in discovery, because you all should have those. I mean, Ms. Love, I think part of it is they're using evidence that arguably they got in discovery. So that shouldn't take that much. That should not take much looking at. Nor should be a surprise to you. However, if it's something that's not been provided in discovery that they wish to go ahead and examine, I would say that probably needs to be disclosed consistent with reciprocal discovery rules.
Yes, Your Honor, and I do not mean to disclose it to us. I mean, no matter what it is, just so that it's labeled, so that we can properly speak to it on the record. If they know that they are introducing 12 pictures that the state has provided in discovery, and they are calling them defendants 29 through whatever, if they would simply say, okay, here are the pictures so that we can speak to them even when we get up to redirect. Okay, I'm going to show you what has been marked as defendants 29, 30.
So are you saying it's a labeling issue?
It is. And of providing to the state which exhibits comport with which defense number. We have had the circumstance where a computer is taken to a witness and the witness is shown unnumbered photographs, and we have had to stop and say, we need to know what is being shown and how you have labeled them so that we can speak to them.
I understand. All right, so both sides can do that. Remember, if you show a witness a document, even if it's for refreshing recollection or whatever, or it's not admitted, it still has to be identified for purpose of record. So I'll ask that all of you do that. All right. What other issues haven't I dealt with pursuant to your motion, Mr. Weinstein?
Thank you, Your Honor. I just hope I get some clarification.
Sure, to the extent I
I'm
can
sure the
give.
court understands, but I don't understand. When the state says they have 120 days of direct examination, that's 120 court days, correct? So we're looking at about 6 months more of their case in chief, assuming we ask 0 questions on cross-examination. 120 days, is that 4 months? Or is that, if we're going 4 days a week, for example, are we talking 30 weeks?
We're talking 120 days.
120 court days. 120 court days.
Are you talking about 120 court days?
Yes. That's right.
120 court, assuming no, and then we have to add in our cross-examination. So we're
Yeah.
here with the state's case in chief through the Super Bowl
That's 6 months.
or more.
Yeah.
Okay.
And Your Honor, that is a it's not precise, and I can do more. It's as precise as I can give to the court at this moment. And Your Honor, I have stated to the court and to counsel for the defendants where it was that we were trying to conclude this case by.
Your Honor, I'm sorry. Can I go? Yeah. Your Honor, courts in the 11th Circuit, the 7th Circuit, the 5th Circuit, the 3rd Circuit, the Western District of Pennsylvania, the Northern District of Iowa, the Eastern District of Kentucky, the District of Mass, and I could probably go on and on if I had more time to research, have used the combined power that you have under 403 and 611 to limit witnesses, limit the number of witnesses, and or put time limits on the state. What I sent you this morning, just to clarify, and I should have made it more clear in my email, and that is my fault, was those were not additional arguments or amendments to my arguments. Those were courtesy copies of cases that were cited in the motion or additional cases that I was going to use in my argument. And that was just for the convenience of the state and for the court, so y'all didn't have to pull those up. But they weren't last-minute arguments. But Your Honor, and I'll sit down after this because I do believe that you've already made up your mind. But I would just ask the court to reconsider, because I do appreciate that you're trying to grab the bulls by the horns here and make us more efficient. And I don't doubt that those 5 rules that you've put in place will make us more efficient, but we're still trying to be more efficient at something that is going to go on for years. This length of time doesn't include our cross, and it doesn't include our case in chief. So while the state says that I cannot ask for what I asked for under 403, fine. Okay? Why don't you put in time limits? It's done over and over again by courts, Your Honor. Because right now, 150 witnesses, 120 court days just of direct examination. I mean, we're going to be making Super Bowl bets with each other in 2026, Your Honor.
Do you have any Georgia case law that allows you to limit the length of witness, I mean the time of witness testimony? Because ordinarily, it's a thorough and sifting examination.
Exactly. And
So-
no, I do not have Georgia case law, but U.S. Supreme Court case law under Getters says that you are not a mere moderator, that if truth and fairness are not to be sacrificed, the judge must exert substantial control over the proceedings. And don't misunderstand me. I understand that you have exerted control. But what I ask is that you listen to what some of these other courts have done. The Reeves case, okay, the Reeves case, Eastern District of Kentucky, it's not controlling. You don't have to do what they say, but I will tell you, it's been cited 69 times throughout the U.S. about how a court needs to get a hold of a case so that you are running the case, Your Honor. You are controlling the court, not either of us, not the state, not the defense. I mean, you read my briefs. You know what they say. I'm not going to repeat it. But if you leave it up to us, we're going to do everything that we can to put on as many witnesses as we can to hammer home our case. And unless you put some kind of control, as we can see by another 150 witnesses coming out, unless you exert some type of limit, we are never going to get through this. Even working on the weekends, which I really would rather not do. Even working on the weekends, we're not going to get through this case, Your Honor. And let me add something else, just briefly, and I know you didn't want to hear argument, but I want to mention something that wasn't specifically in there. We are losing our jurors. We are losing our jurors. I look over there at them, and they are trying their best. They are trying their hardest. Often they are taking notes, but other times they have just tuned out. Tuned out. In a study from 1987, looking at long trials being more than 20 days, and short trials being less than 6 days, in long trials, 46% of the jurors found that evidence was difficult or very difficult as compared to jurors in short trials, 29% in short trials. 7% of them in long trials said that the evidence and testimony was dull, or I'm sorry, very dull, as compared to 0% in short trials. And then here's the thing I'm most concerned about, Your Honor. In long trials, 46% of jurors had their attention wander quite a bit or occasionally, versus 24% in short trials. We are way beyond a long trial. And these studies were done back in the 80s, And when social scientists have been looking at this, in 2004, under a certain measure of attention span done at UC Irvine, the average attention span that you could focus on something, an average person was 2.5 minutes. Now we're down to 47 seconds. So these jurors in the 80s who found that their attention wandered, they're not even close to not wandering anymore. I'm really afraid that what we're going to end up with is a situation where the jurors are making their decision not based on 2 or 3 years of evidence presentation, but on how well the advocates do in their closing arguments.
All right, sir.
Thank you for hearing me out on those additional
You're very
issues.
welcome. You're very welcome. All right. I state with that revised witness list, I do want to see broken out pursuant to count and overt act how many witnesses you do have, because I do want some fidelity in the 150. Okay.
We can do that, Your Honor.
All right. Okay. You want to add anything else, Ms. Lowe?
No, Your Honor.
Okay. All right. I'm going to have an order. Mr. Kearns and I will work on an order, an administrative order, and I will include the list of witnesses that you need to present by tomorrow to me. Because what I want to do is I want to look at them and I want to kind of discuss them with your colleagues, so that there's no hide the ball. We know everything that we're kind of doing at this point in time. And like I said, we'll take a look at it, because, we're looking at another 6 months, and I just think that's, we're asking a lot of our jurors. So I want you to really look at the number of witnesses you are going to call and the number of counts you're going to prove. Now, I know, Ms. Lowe, you indicated earlier you weren't really willing to share with what you, in streamlining your case, what you were going to go ahead and do, but you need to look at what you're realistically going to present. So I'm not trying to invade your case, but I think at this point in time, given how long it's gone on so far, I'm going to press a little bit.
Your
And
Honor.
I think that the law allows me to do that at this point under 611 because of how long we've gone. So.
And Your Honor, thank you, and we will certainly comply with the court's directive. We would point out, as the court is well aware, as our defendants, that of course it is the state with the burden of proof, and Your Honor, the court's discretion with respect to limiting or directing or how the trial progresses also extends to repetitive questions asked by counsel for multiple defendants. And so, Your Honor, we would ask that the court also consider fashioning remedies that include, when there are questions asked by one defense counsel, that another 3 cannot get up and ask the same thing, though they are representing different people. Additionally, Your Honor, as I stated, we have no problem providing to the court and counsel the witnesses that we intend to prove up our case with. I've never had any problem with that. So we will be giving that to the court tomorrow as directed.
All right, and then we can discuss what witnesses are going to be called, because I'd like to. I'm gonna do an administrative order based upon that. Yes, Mr. Weinstein.
Your Honor, I don't believe that you need the additional element that the state has asked for, that you put in there that we cannot ask redundant questions. I believe the court has done a.
Well, I'll interrupt you because I mean,
Court
so
has shown that you are willing to jump in if you believe our questions are redundant
or repetitive.
or repetitive.
Yes. Okay. All right. So, all right, councilors, thank you very much. So we'll continue this discussion tomorrow morning, depending upon what the state, in terms of the witness list. Any other council wish to be heard on this particular issue, even though you didn't file a motion? Anything you wish to add or comment upon? All right, hearing none, you're welcome to do so. But tomorrow morning, I will be asking for conversation with the rest of the witness list. Okay?
Yes, Your Honor.
Thank you.
Mr. Steele?
Can't get on the internet here, but a case was decided this year, 2024, from the Ninth Circuit. Hartman, Hartmann. It's from Montana. And that judge did do what Mr. Weinstein asked about time limits, and it got reversed. And the Ninth Circuit said, you cannot do it to a criminal defendant. That may be different in a civil case.
Civil case, yeah. Okay. All right. Thank you, sir. That wasn't one of the plans I had planned on doing anyway, so. Because I believe that that's inconsistent with your rights to have a thorough and sifting cross-examination. So, and under the Sixth Amendment, I wouldn't allow that anyway. So, but Mr. Weinstein, no harm in asking, okay?
No,
All right.
But
Hartman, yeah.
everyone tells us we have to arm the court with the laws.
Okay, all right.
Judge, I don't believe that there's been a problem with the defense attorneys asking repetitive questions. I think the court has been able to identify that and deal with it accordingly. So I would just respectfully ask the court to continue as it has been in that regard. I don't think lawyers would be getting up and just asking the same questions over and over.
But you do need to identify yourselves when you get up, so Ms. Weaver is not mad at you. So if you could work on that, Ms. Weaver would be greatly appreciative. All right. Okay. All right. Okay. Anybody else? All right. So we'll take up the rest of that tomorrow morning in terms of the witness list and categories and counts and over at ACT. So when we come back in tomorrow morning, let's go ahead and turn to.
Your Honor, excuse me, I'm sorry.
Yes, sir.
Regarding returning tomorrow morning, I believe that you asked us when we're only at administrative days to try to take care of doctor's appointments and other issues that we may have. I know tomorrow was originally scheduled as an administrative day, so I'm not sure if.
I said if we're done.
Well, it was originally Monday and Tuesday.
And I told you Tuesday and Wednesday.
Unfortunately, because of that death, you moved to Tuesday, Wednesday.
I did.
But I believe some people may have already scheduled appointments on Wednesday. I don't know if you could maybe inquire and start later or something to that effect,
Why would I want to do that?
so that the attorney.
Why would I want to do that? I mean,
Because you're a kind man.
let me tell you what the Jamaicans say. Off of me, right?
Excuse me? Oh, yeah.
Off of me, right?
I can only ask her on it, so.
Is there anybody that's going to be an issue with? I can't see you. Miss D. Williams?
Yes, Your Honor. I have a doctor's
What time, madam?
appointment at 8:30 a.m.
Okay, so if we started it at 11, would you be okay with that? Okay.
Thank you.
We can reasonably accommodate that. All right, so that's what we'll take up at 1100 hours tomorrow. Once we're done with that, I don't think we'll have anything else in that respect. Okay. All right. Okay. Let's see if we can take up the rest of we got a couple of just things that we need to kind of just take up at this point, and that would be the motion to exclude or redact the conviction of Mr. Winfrey, and that was filed by Mr. Steele. So, sir.
So, Your Honor, Jimmy Winfrey is a co-indictee in our case. He is obviously not here. He's severed. I understand he's in custody. I believe he's in custody anyway. He was previously arrested and indicted in Cobb County, and that is for an April 26, 2015 alleged shooting at a tour bus that was occupied by a performer, Dwayne Carter, known as Lil Wayne. And he went through with very fine lawyers, and he pled guilty. He then appealed with another very fine lawyer, different lawyer, that his guilty plea was coerced by the trial court, and the Honorable Court of Appeals of Georgia disagreed. The Honorable Supreme Court of Georgia agreed with Mr. Winfrey. They vacated and said that the trial judge got involved was coerced the plea.
Excuse me.
So Mr. Winfrey then eventually pled guilty again. And I believe, I have to check my notes, but it was an Alfred plea, I believe. Anyway, he's now here. So I've always objected that a co-indictee who's not testifying that their guilty plea is confrontation clause. It should not come in at all. But in this particular case, Jeffrey Williams' name is placed in the original indictment, and an indictment is the prosecutor's hearsay. It's rank hearsay. That's according to State versus Brown, which is 298 Georgia, 878, 2016 case. I cited in division or paragraph 4 of this motion that I filed on September 15, 2023. So I asked the state, and they're going to alert the court. But, you know, if there's an issue with anybody putting in Mr. Winfrey's plea it'll be over objection. But if there is, I don't want Jeffrey Williams' name to be in it. He was not charged. He's not pled. He was not arrested. But there was information that the grand jury through the Cobb County DA's office asserted that Jeffrey Williams is an unindicted co-conspirator. So that was my motion.
Okay, all right, State.
Thank you, Judge. Your Honor, I believe that the case that Mr. Steele cited for the court has to do solely with the state using an indictment of a non-co-defendant person to prove the existence of a gang. The indictment, State v. Brown, involves the state simply taking an indictment in an entirely different case of an alleged gang member who is alleged to be a member of the same gang as Brown, and using the indictment itself alone to prove the existence of a gang. Whereas in our case, the shooting of Lil Wayne's bus is not only alleged to have been done by the criminal street gang member of YSL, that is Jimmy Winfrey. It is also alleged as an overt act in our indictment. Now, what the state does not intend to do, which we believe would comport with the spirit of Brown, is we do not intend to put in the counts to which are not at all referenced, or which Mr. Winfrey, which not only did he not plead to, but they're not referenced in any of the counts that he pled to. And along those lines, the counts to which Mr. Winfrey pled guilty are counts 5 and 7 of indictment 152765 in Cobb County Superior Court. And count 5, Your Honor, of that indictment states as follows: and the grand jurors aforesaid in the name and behalf of the citizens of Georgia further charge and accuse Jimmy Carlton Winfrey with the offense of violation of the Street Gang Terrorism and Prevention Act. For that, the said accused person on or about the 26th day of April 2015, being associated with the Bloods, a criminal street gang, did unlawfully participate in criminal gang activity through the commission of the offense of violation of the Racketeer Influenced and Corrupt Organizations Act as set forth and described in counts 1 through 3 of this indictment and incorporated herein by reference, contrary to the laws of said state, the good order, peace, and dignity thereof. Similarly, count 7 reads that the grand jurors accuse Jimmy Carlton Winfrey of violating the Street Gang Terrorism and Prevention Act. For that, on the 26th day of April, while associated with the criminal street gang, he participated in criminal gang activity through the commission of the offense of criminal damage to property in the first degree as set forth and described in counts 25 through 26 of this indictment and incorporated herein by reference, contrary to the laws of said state, the good order, peace, and dignity thereof. That said, the state would only be introducing as part of the certified conviction of Jimmy Winfrey the indictment portions that reference either counts that he pled to or counts that were incorporated into the counts that he pled to, as indicated in the language itself of the counts. So that would mean counts 1 through 3.
Do any of those counts reference Mr. Williams?
They do reference Mr. Williams, Your Honor, because Mr. Williams, as alleged in this indictment, was a part of the act that Jimmy Winfrey committed when he shot up the bus that was Lil Wayne's tour bus. So, Judge,
can I see it?
Yes, Judge. And I will give to the court both our certified copy.
And that's already been provided to the defense in this case?
Your Honor,
I have my own.
Okay. All right.
which consists of the original indictment and plea, and then the subsequent indictment and plea, guilty plea, which was entered in 2020. And then we also have a copy of the indictment and counts with the redactions that we intend to include. So the first document that I gave to the court, and we would not be admitting the first indictment and guilty plea, we would be entering the second one, which is about midway of the entire certified.
Okay, so this is the first one, the first copy of the indictment?
If
Oh,
the
is
court
it?
will allow me to have it back, I'll go ahead
Sure.
and separate it out.
Yes, please.
Your Honor, I'm giving to the court the guilty plea entered in the year of 2020, the most recent guilty plea. And the second set of documents is the guilty plea with the indictment, rather, with the redactions that the state intends to include. And that means redacting count 4, counts with the exception of counts 25 and 26. So counts 1 through 3, 5, 7, and 25 through 26 are the only ones that the state would intend to utilize. And that is what Mr. Winfrey pled guilty to. That is one of the overt acts alleged in this indictment. And given that Mr. Winfrey is a co-indictee, an accomplice, and an alleged gang member and member of the criminal enterprise that is Young Slime Life, the state's position is that the state is entitled to show that Jimmy Winfrey entered a guilty plea. An Alford plea does not negate the fact that it is a guilty plea to those counts and to those allegations alleged and incorporated in those counts in that indictment.
Let me ask you a question, Ms. Love. Is it your intent to call Mr. Winfrey at some point in time?
Your Honor, our intent is not to call Mr. Winfrey. Our intent is to prove up the case that Mr. Winfrey was to present evidence independent of the indictment itself.
I mean, are you going to put him, or is it your event, are you going to call him during your case in chief?
Mr. Winfrey, no,
Yes,
but
why
we're
not?
going to, Your Honor, because he is so there are two things. We intend to prove up the case itself. We don't intend to just put in an indictment.
Well, I'm saying if you called Mr. Winfrey and you wanted to, consistent with your case in chief, and for example, asked him questions about his involvement, then certainly I could see how that indictment might then be appropriate to show knowledge or to impeach. But that's why I asked you that question. It wasn't for the court asking any other purpose. But
Judge, it'll be similar to the certified copy of the indictments of Shannon Stillwell that we've entered. And Mr. Stillwell, I cannot compel him to testify. It would be similar because Mr. Winfrey is awaiting trial in this case. I cannot compel him to testify. In this case, he is, as Mr. Stillwell is.
Did he plead? Did he plead, or is he?
He pled guilty to the Cobb County case, not to this case. He is on this indictment.
Is he in the other Splinter case that we have in this case? Is he in?
Yes, he is. I'm sorry. Yes.
Okay, all right. That's what I meant. The other matter that my colleague Judge Dempsey is
Yes.
handling at this point in time. So he's in that case.
Yes.
Okay, I understand. Okay, all right. Okay. It's a certified copy, but that gets you the record. Okay, that gets you the record. Mr. Steele's still got an argument that would be hearsay at that point. Is that correct? Mr. Steele, is that correct?
Of course.
It's a self-authenticating document, Your Honor.
That gives that with self-authenticating documents, you still have other bases for objection, meaning that you can get the document in and under the self-authenticating clause, but it's still subject to or provision, but it's still subject to other objection.
So, Your Honor, what we would not be doing is just entering, and that was what I was saying at first. We would never just enter the certified copy of even the conviction without proving up the facts that are alleged within the document itself. So we won't be offering up a certified copy of the conviction and then resting on that and saying, here you go, here's proof that someone who is not sitting at the table right now did these acts, and that goes to prove the existence of the enterprise and the criminal street gang that is YSL and their association. What we will be doing is putting the case up to the jury that Mr. Winfrey pled guilty to, essentially. We will be putting up the facts of that case because they are alleged overt acts that we have to prove. We cannot just put up the conviction. We will be putting the witnesses up that prove that case.
I understand that, but to Mr. Steele's argument,
And we will be putting up the evidence that shows that what is alleged and to the counts that he pled guilty,
that's Mr. Winfrey, that is.
Your Honor, we will be showing not only Mr. Winfrey, but the association with various members of YSL that are included within the indictment. In other words, we will be proving up as if we were on trial in that case. We will be proving up the various elements of that case against Mr. Winfrey.
But here's the thing. The indictment references Mr. Williams, who was not on trial for that case.
We will be proving what is alleged in the indictment regarding Mr. Williams as well. We will be proving it with witnesses, not just with that certified document.
I'm not saying it might not come in, but I don't know if it'll come in at this point in time. But I have some concerns. I understand what you're saying. You're saying, okay, we're going to prove Mr. Winfrey's conduct, okay? And Mr. Winfrey's pled guilty to this indictment, the second indictment anyway, so that certainly would be appropriate. But I think that you would probably have to redact out Mr. Williams' involvement at this point.
So, Your Honor, prior to and without putting up evidence of what Cobb County alleged in that indictment regarding Jeffrey Williams, I would understand that requirement. We intend to put up that information, and it would not be hearsay when the state has proven the allegations that are made in the indictment. And that is what we intend to do. We intend to prove the
But wouldn't it be cumulative at that point of other evidence? I mean, here's the thing. I think that it might come in. It might come in. It really might. But I think it's going to depend upon what is testified to. I mean, I certainly understand with Mr. Winfrey, you could probably use this indictment for whatever he's pled guilty to. And that would not be an issue. But I think Mr. Steele on behalf of Mr. Williams is indicating at this point now that, he's objecting to it because it certainly would be considered, hearsay. Even though the document itself, under the self-authenticating clause would be admissible, it still would be subject to other objections. Also, I could foresee, depending upon what is testified to, then the facts in this indictment may become more relevant, meaning that should the door be opened as to things in this particular indictment, then other things might be, certainly the court would reevaluate at that point in time. But I think in your case in chief, it's subject to some valid objections.
Yeah.
That's just what the court's thinking of at this point in time. Mr. Steele, anything else?
No, sir.
Okay. So do you understand what I'm saying at this point in time? If you wish to go ahead and use the indictment, that's fine. I think the redaction would be appropriate, but you'd have to redact out anything involving Mr. Williams at this point. Now, that's subject to if somebody opens the door as to that particular issue, either from from cross-examination by the defendants or in their case in chief, should they decide to present any evidence and not requiring them to do so. But then that would be, certainly the court would relook its position under that particular set of facts.
And so what I think we'll be doing, Your Honor, is not even introducing the exhibit until we.
Your choice, okay? Because here's the thing, even if you introduce the evidence, it's subject to other, it could be, I'm not saying it will be, but it could be subject to other additional objections.
Yes,
Okay? All right, the document itself, but I'll leave you, I'll take it up. At this point in time, I'm inclined to
Your Honor, if you've not tendered it.
like I said, I'm giving my preliminary thoughts on it. That if you decide to issue it in your case in chief, it would be subject to redaction. So you can use that for your thoughts. If you decide you don't want to, introduce it this one time, then I'll take it up later.
And Your Honor, I would ask that the court take it up later because we will
Okay.
not be tendering it until we reach the point where we felt we had proven the various
Okay.
allegations or assertions.
And I'm saying to you, it might be subject to other additional objections, depending upon what's presented. You want me to give you this back? Okay. Yes. Yes, you can have those both back for the time being? Okay.
Thank you, Judge.
You're welcome. What's that? Who? We'll just recess in place. Wes. All right. All right, Mr. Steele, let's take up the motion for notes and recordings for Mr. Derek Wise, or has that been satisfied already?
Your Honor, this was filed on December 15, 2013, and based upon my belief,
2023.
yes,
Okay, all right.
based upon my belief, Mr. Derek Wise has nothing in the discovery. By that I mean I have no statement from him in any fashion in the discovery. And then on December 13th, pursuant to your order, 2023, the Honorable District Attorney Hilton, has always been nothing but professional. She assisted me, and we spoke together with Mr. Wise. And Mr. Wise, according to Ms. Hilton, was supposedly at the barbershop, just so the court knows. And the barbershop is where Donovan Thomas walks out of when he, God forbid, is shot and killed on January 10th, 2015. So Mr. Wise is in that barbershop. Ms. Hilton told me that Mr. Wise spoke with a member of her office, and he was supposedly at that barbershop at the date and time. Ms. Hilton also told me that the state plans on calling Mr. Wise as a witness at trial. That was before the pared down witness list. So this may be moot if he's not on the 200-person witness list, but when I filed it, I was told he's going to be a witness. I have nothing at all, and because when I spoke with Mr. Wise with Ms. Hilton on December 13, 2023, Mr. Wise told me, and he was very professional, he said that he has nothing to add to this case. He does not know why he's being called as a witness. He has no relevant information whatsoever. Those are my words, but that's what he told me and Ms. Hilton. And if that statement is inconsistent with something that the state is calling him for, then I'd like to know what he said to this state's representative. That's the entirety of the motion.
Your Honor, I can
Okay.
address that with the court's permission.
Yes, yes, ma'am.
So there are no statements, there are no reports or statements of Mr. Wise. I spoke with Mr. Wise over the telephone after a member of our office obtained his phone number for me. He said that he was at work at the barbershop at, I believe it is 336 McDaniel Street, which would have been the one that Mr. Thomas was inside prior to going outside, where he was gunned down. That barbershop is listed on the map as A&M Barbershop. It is the one to the immediate right of the barbershop at 330 McDaniel Street, where Mr. Thomas failed after being gunned down. Mr. Wise indicated that he heard the gunfire. He ran outside after the shooting occurred, and he witnessed Mr. Thomas mumble some words and then take what Mr. Wise believed was Mr. Thomas's last breath. That is the extent of what he shared with me. I believe that he may have spoken of haircuts that other people were getting that Mr. Thomas was paying for. He did not recall to me, he did not relate to me seeing or being able to identify the shooters, but he did state that he heard the gunfire and that he ran outside and he observed Mr. Thomas after he was gunned down, and that he interacted, or at least he was inside the barbershop at the time prior to Mr. Thomas left the barbershop before he was gunned down.
Okay, to the extent that that's or in addition to what Mr. Steele and Ms. Hilton know, Was that anywhere memorialized by any investigative team or any other?
No, this was a oral conversation that I had with Mr. Wise on speaker in my office with one or more of our lieutenants present.
Your investigators?
Investigators.
All right. To that extent, has that been reduced to writing, or is that been made known to Mr. Steele and any of the other councils?
Orally, I think I may have already spoken and indicated as much, but I can send this this email that I constructed that says what I just relayed to the court. I can send that to them, but that's the extent of the information that I have to provide to Mr. Wise.
Okay. All right. I'll direct that you send that to councils, and if they have anything that, as a result of that, they can file whatever motions or take up anything they wish to at that point.
Yes, Your Honor.
May I just inquire one other thing?
Yes.
Thank you. Attorney Love, if you could also, when distribution writing, just explain how Mr. Wise came to everyone's attention. Because as Attorney Steele said, there's no mention, at least that I know of, in the discovery. So I'm just wondering how it fit in to this whole scenario.
I can tell the court, I can put that on the record. I called the barber shop that is located at 336 McDaniel Street. I called the other barber shop, looking for who I believe was the owner of the barber shop. And I ended up speaking with Mr. Wise when I called, looking for another person who I thought was the owner.
When was this? When did this conversation occur? When did it occur, Madam? On or about?
I'm thinking, maybe December or whenever it was, we provided his name on the witness list. I don't remember the exact date. If his name was on the witness list before December, then it may have been November. It was whenever it was that we, right before we put his name on the witness list.
Okay. All right. This is kind of what I mean earlier about it's important to, I mean, I know that the witness has been disclosed, but any statements or anything that you know, would be appropriate to disclose, or at least that we had an interview with them. Here's, you can follow up with it. We
I did,
talk with
and
them.
that's the reason we were providing him for them to talk to, but when he didn't want to speak with them, I believe we
Mr. Wise didn't want to talk to them?
I think so, Your Honor. That's what Mr. Steele just said. If I'm not mistaken, I apologize to the court, but I believe Ms. Hilton facilitated a communication or conversation between Mr. Steele and Mr. Wise, and Mr. Wise didn't want to talk to him.
Okay. All right. Anything else? All right. So Ms. Love's going to construct that email, and if you wish to file anything as a result of that, let me know and do so timely. Okay. Anything else as it pertains to Mr. Wise? All right. Let's move to the state's motion to bar self-serving and self-quoting hearsay. All right. Ms. Love, is that yours?
Yes, Your Honor.
Okay. All right.
Motion, Your Honor, generally what we have been doing when there is an attempt to introduce self-serving hearsay is that we have been making objections as the instances arise. There were times during opening statements that we believe self-serving hearsay was introduced or was put before the jury. We are aware that attorneys' words are not evidence, but to the extent that any party seeks to introduce self-serving hearsay, Your Honor, we are making a motion in limine to preclude that, as the court is aware that that is not allowed. But we understand that until that time presents itself where it is offered, there's nothing specific for the court to make a ruling on. We don't know what hearsay counsel for either defendant intends to try and elicit from any witness, but we are simply placing counsel for defendants and the court, making the court aware that we do object to self-serving hearsay. and we'll be making objections as those instances appear before this honorable court.
All right. Any argument on behalf of any counsel? Mr. Steele, we'll start with you.
No, we'll just follow the rules.
Okay.
To add.
Mr. Weinstein.
No, Your Honor.
Mr. Matthews.
No, Your Honor.
Ms. Westmoreland.
We would just ask the state that if they identify or can predict self-service techniques in reference to our client, that they either have a particularized motion or at least have a discussion that's showing the court on a full-fledged 3-hour argument, and that you're trying to avoid here.
And Your Honor, as we have been instructed by the court repeatedly, since we are not entitled, whatever it is that counsel may want to introduce prior to them making it known that they're wanting to introduce it, I cannot read their minds and predict what self-serving hearsay they may intend to try to introduce. We just object to any self-serving hearsay that they may try to introduce.
Yeah, because what the state's trying to say is that, and all you counsel know this accordingly, until it's your case in chief, what you're stating or what you're trying to introduce would be considered to be objectionable. So to the extent that I hear it, I'll rule on it, but that's just what they're asking to preclude. Okay.
And even in their case in chief, unless it's their client who's presenting it, we would object to them introducing words of their clients without the state having the ability to cross-examine them. And that is the whole reason for, of course, as the court is aware, that prohibition.
Yes, ma'am.
Thank you.
Ms. T. Williams? Mr. Sharp?
No, thank you, Your Honor.
Okay. All right. To the extent that, like I said, you all know the rules, in terms of 24-8-801 D and D2, I will make appropriate rulings as are required, but I would just advise any litigant that to just make sure that they review the under Title 24 those rules as it relates to self-serving or self-quoting hearsay. So, all right. Okay. Anything else that I think that's all the motions that we had to take up for today. As I mentioned, tomorrow at 11, we'll take up the rest and residual of the administrative order that the court's going to enter. I'm looking for the state's witness list consistent with the court's directives today. We'll talk about that. So, Ms. Lovis and your team, as soon as that can be sent out, as early as it can be sent out, so we can at least have something to talk about. And I would ask that any defense counsels who believe that there are issues of duplication, replication, cumulative, or any other basis that you come prepared to talk about those at that point. Because I do have some concerns about 120 days of trial time. That's going to take almost 4 months. And, I'll remind the state, you told me, or Ms. Hilton told me, it's going to take about 6 months. At this rate, it's going to be 12 months, and that doesn't include anything that the defense may choose to. I'm concerned about your case in chief at this point in time. The defense will present whatever they wish to do with, and I'll deal with it. We'll deal with it accordingly. But
we were trying to be finished by June, frankly, as I told the court earlier.
Yes.
We can't control cross-examination, and that has extended our estimation of the time that we expect.
Well, like I said, if you disclose things, if you don't disclose everything, and we don't disclose things timely, then then what I'm doing is I'm taking up more time. What I want to do is I don't want us to take up 2-3 hours. I can't do that anymore. So I'm telling you, you need to make very sure that you've disclosed the evidence and you be able to tell me what day you did, because if you can't, I'm gonna exclude it. That's my remedy at this point in time. That's my first remedy I'm gonna turn to, because I don't want to initially do that, but I've kind of gotten to the point right now where it's kind of like, I don't think that a lot of things I do are for abuse of discretion. I don't believe that, given what I have indicated to all of you as a group, is not a valid assertion at this point in time. It's just taking way too long. So, you all can help me out or help yourselves out by identifying issues. And then if we got to kind of just take them out of turn and I got to take a day and deal with them, that's fine. But, I need to make sure that everybody's kind of on the same sheet of music, that we're not kind of just stopping things. Oh, I wasn't given that. Or like I indicated earlier, we just found something on Instagram last night. Well, then it should have been turned over within the hour that you found it with a we need to talk to the court in the morning about it first thing. So a lot of times, so we can be kind of forearmed and take care of it. So that's what I kind of want everybody to kind of work on. I'm not interested necessarily in taking up your weekend. I really am not. And I'm not interested in holding any of you in court, but those are tools. They're tools. And I mean, we are more than a year's worth into this, and we are 40 witnesses deep. So I'm just telling you all, just think about and kind of just in conjunction with what I've told you all earlier today, and then we'll talk about the witness list tomorrow, and we'll see what we can kind of get proceed better with. All right. So that's tomorrow. We'll start at 11, whatever, and we'll finish that discussion. We'll be done for the day, and then at 9 a.m. on where's Captain Kendall? Is she back? Brown, can you radio over, please? Right now, I'm looking to handle, Ms. Love, as I mentioned earlier, you and your team, your response needs to be filed, and it's by 5 tomorrow, and I need to have a copy of that so I can read it, and then my plan is to take that up on the 4th Thursday at 9 a.m. Okay? All right, any other administrative councils?
Not on behalf of Mr. Williams.
All right, then I will see you all tomorrow morning at 11, okay? All right, we're in recess. Thank you much.
So she's on the way up.
Okay, you can come upstairs.